All right, folks, that concludes the presentation of evidence. We have some work to do on jury instructions, but there's a number of jury instructions that I can read now. So rather than do those on Tuesday, I'm going to read a set of jury instructions. There will be additional jury instructions read on Tuesday. The order in which I read these instructions is not important, so to the extent that I read some today and some on Tuesday, pay no attention to the fact that they are given at different times. Does not mean that any have any more significant meaning than any of the others. And the parties have stipulated that the jury instructions do not need to be recorded by the court reporter, so at this time she can stop doing so. All right, and again, I'll read these quickly. They'll be available to you in the jury room. Members of the jury, you have now heard all the evidence and will hear the closing arguments of the attorneys. It is my duty to instruct you on the law that applies to this case. You must follow these instructions as well as those that I previously gave you. You have a copy of my instructions with you when you go to the jury room to deliberate. You must decide what the facts are. You must consider all the evidence and then decide what you think happened. You must decide the facts based on the evidence admitted in this trial. Do not allow anything that happens outside this courtroom to affect your decision. Do not talk about this case or the people involved in it with anyone, including family and persons living in your household, friends and co-workers, spiritual leaders, advisors, or therapists. Do not do any research on your own or as a group. Do not use dictionaries or other reference materials. These prohibitions on communications and research extend to all forms of electronic communications. Do not use any electronic device or media such as a cell phone, smartphone, PDA, computer, tablet, device, the internet, any internet service, any text or instant messaging service, any internet chat room, blog, or website, including social networking websites, online diaries, to send or receive information to or from anyone about this case or your experience as a juror until after you've been discharged from your jury duty. Do not investigate the case or conduct any experiments. Do not contact anyone to assist you, such as a family accountant, doctor, or lawyer. Do not visit or view the scene of any event involved in this case. If you happen to pass by the scene, do not stop or investigate. All jurors must see or hear the same evidence at the same time. Do not read, listen to, or watch any news accounts of this trial. You must not let bias, sympathy, prejudice, or public opinion influence your decision. If you violate any of these prohibitions on communications and research, including prohibitions on electronic communications and research, you may be held in contempt of court or face other sanctions. That means you may have to serve time in jail, pay a fine, or face other punishment for that violation. I will now tell you the law that you must follow to reach your verdict. You must follow the law exactly as I give it to you, even if you disagree with it. If the attorneys have said anything different about what the law means, you must follow what I say. In reaching your verdict, do not guess what I think your verdict should be from something I may have said or done. Pay careful attention to all the instructions that I give you. All the instructions are important because together they state the law that you will use in this case. You must consider all the instructions together. After you've decided what the facts are, you may find that some of the instructions do not apply. In that case, follow the instructions that do apply and use them together with the facts to reach your verdict. If I repeat any ideas or rules of law during my instructions, that does not mean that these ideas or rules are more important than the others. In addition, the order in which the instructions are given does not make any difference. Most of the instructions are typed. However, some handwritten or typewritten notes may have been added, and some words may have been deleted. Do not discuss or consider why words may have been added or deleted. Please treat all the words the same, no matter what their format. Simply accept the instruction in its final form. You may consider the ability of each party to provide evidence. If a party provided weaker evidence when it could have provided stronger evidence, you may distrust the weaker evidence. You may consider whether one party intentionally concealed or destroyed evidence. If you decide that a party did so, you may decide that the evidence would have been unfavorable to that party. If a party failed to explain or deny evidence against them when they could reasonably have done so based on what they knew, you may consider their failure to explain or deny in evaluating that evidence. It is up to you to decide the meaning and importance of the failure to deny evidence against the party. During the trial, you received deposition testimony that was read from deposition transcripts or shown by video. A deposition is the testimony taken of a person before trial. At a deposition, the person is sworn to tell the truth and is questioned by the attorneys. You must consider the deposition testimony that was presented to you in the same way as you consider testimony given in court. Before trial, each party has the right to ask the other parties to answer written questions. These questions are called interrogatories. The answers are also in writing and given under oath. You must consider the questions and answers that were read to you the same as if the questions and answers had been given in court. A party may offer into evidence any oral or written statement made by an opposing party outside the courtroom. When you evaluate the evidence of such a statement, you must consider these questions. Do you believe that the party actually made the statement? If you do not believe that the party made the statement, you may not consider the statement at all. If you believe that the statement was made, do you believe it was reported accurately? You should view testimony about an oral statement made by a party outside the courtroom with caution. During the trial, you heard testimony from expert witnesses. The law allows an expert to state opinions about matters in the expert's field of expertise, even if the expert has not witnessed any of the events involved in the trial. You do not have to accept an expert's opinion. As with other witnesses, it is up to you to decide whether you believe the expert's testimony and choose to use it as the basis for your decision. You may believe all, part, or none of an expert's testimony. In deciding whether to believe an expert's testimony, you should consider the expert's training and experience, the facts the expert relied on, and the reason for the expert's opinions. The law allows expert witnesses to be asked questions that are based on assumed facts. These are sometimes called hypothetical questions. In determining the weight to give the expert's opinion that is based on the assumed facts, you should consider whether the assumed facts are true. If the expert witnesses disagreed with one another, you should weigh each opinion against the others. You should examine the reasons given for each opinion and the facts or other matters that each witness relied on. You may also compare the expert's qualifications. A witness who was not testifying as an expert gave an opinion during the trial. You may, but are not required to, accept that opinion. You may give the opinion whatever weight you think it is appropriate. Consider the extent of the witness's opportunity to proceed the matters on which the opinion is based, the reasons the witness gave for the opinion, and the facts or information on which the witness relied in forming that opinion. You must decide whether the information on which the witness relied was true and accurate. You may disregard all or any part of an opinion that you find unbelievable, unreasonable, or unsupported by the evidence. Ms. Ellis claims that she was harmed by Ms. Almanzar's negligence. To establish this claim, Ms. Ellis must prove all of the following: that defendant was negligent, that plaintiff was harmed, and that defendant's negligence was a substantial factor in causing plaintiff's harm. Negligence is the failure to use reasonable care to prevent harm to oneself or to others. A person can be negligent by acting or failing to act. A person is negligent if that person does something that a reasonably careful person would not do in the same situation, or fails to do something that a reasonably careful person would do in the same situation. You must decide how a reasonably careful person would have acted in defendant's situation. Causation. A substantial factor in causing harm is a factor that a reasonable person would consider to have contributed to the harm. It must be more than a remote or trivial factor. It does not have to be the only cause of the harm. Conduct is not a substantial factor in causing harm if the same harm would have occurred without that conduct. Ms. Ellis claims that Ms. Almanzar committed a battery. To establish this claim, plaintiff must prove all the following: the defendant touched plaintiff with the intent to harm or offend her, that plaintiff did not consent to the touching, that plaintiff was harmed or offended by defendant's conduct, and that a reasonable person in plaintiff's situation would have been offended by the touching. A plaintiff may express consent by words or acts that are reasonably understood by another person as consent. A plaintiff may also express consent by silence or inaction if a reasonable person would understand that the silence or inaction intended to indicate consent. Ms. Ellis claims that Ms. Almanzar's conduct caused Ms. Ellis to suffer severe emotional distress. To establish this claim, Ms. Ellis must prove all of the following: that defendant's conduct was outrageous, that defendant intended to cause plaintiff emotional distress, that plaintiff suffered severe emotional distress, and that defendant's conduct was a substantial factor in causing plaintiff's severe emotional distress. Emotional distress includes suffering, anguish, fright, horror, nervousness, grief, anxiety, worry, shock, humiliation, and shame. Severe emotional distress is not mild or brief. It must be so substantial or long-lasting that no reasonable person in a civilized society should be expected to bear it. Plaintiff is not required to prove physical injury to recover damages for severe emotional distress. If you decide that plaintiff has proved her claim against defendant, you must also decide how much money will reasonably compensate Ms. Ellis for the harm. This compensation is called damages. The amount of damages must include an award for each item of harm that was caused by defendant's wrongful conduct, even if the particular harm could not have been anticipated. Ms. Ellis does not have to prove the exact amount of damages that will provide reasonable compensation for the harm. However, you must not speculate or guess in awarding damages. The damages claimed by plaintiff are for the harm caused by defendant fall into two categories called economic and non-economic damages. You'll be asked in the verdict form to state the two categories of damages separately. The following are the specific items of economic damages claimed by Ms. Ellis: past and future medical expenses. The following are the specific items of non-economic damages claimed by Ms. Ellis: physical pain, mental suffering, and emotional distress. The arguments of the attorneys are not evidence of damages. Your award must be based on your reasoned judgment to the testimony of the witnesses and the other evidence that has been admitted during the trial. You must not consider or include as part of any award attorney's fees or expenses that the parties incurred in bringing or defending this lawsuit. When you go to the jury room, the first thing you should do is choose the presiding juror. The presiding juror should see to it that your discussions are orderly and that everyone has a fair chance to be heard. It is your duty to talk with one another in the jury room and to consider the views of all the jurors. Each of you must decide the case for yourself, but only after you have considered the evidence with the other members of the jury. Feel free to change your mind if you are convinced that your position should be different. You should all try to agree, but do not give up your honest beliefs just because others think differently. Please do not state your opinions too strongly at the beginning of your deliberations or immediately announce how you plan to vote, as it may interfere with an open discussion. Keep an open mind so that you and your fellow jurors can easily share ideas about the case. You should use your common sense and experience in deciding whether testimony is true and accurate. However, during your deliberations, do not make any statement or provide any information to other jurors based on any special training or unique personal experiences that you may have had related to matters involved in this case. What you may know or have learned through your training or experience is not a part of the evidence received in this case. Sometimes jurors disagree or have questions about the evidence or about what the witness has said in their testimony. If that happens, you may ask to have testimony read back to you or ask to see any exhibits admitted into evidence that have not already been provided to you. Also, jurors may need further explanation about the laws that apply to the case. If this happens during your deliberations, write down your questions and give them to the bailiff or the courtroom attendant. I will talk with the attorneys before I answer, so it may take some time. You should continue your deliberations while you wait for my answer. I will do my best to answer them. When you write me a note, do not tell me how you voted on an issue until I ask for this information in open court. Your decision must be based on your personal evaluation of the evidence presented in the case. Each of you may be asked in open court how you voted on each question. While I know you would not do this, I'm required to advise you that you must not base your decision on chance, such as flip of a coin. If you decide to award damages, you may not agree in advance to simply add up the amounts each juror thinks is right, and then without further deliberations, make the average juror verdict. You may take breaks, but do not discuss the case with anyone, including each other, until all of you are back in the jury room. If you have taken notes during the trial, you may take your notebooks with you into the jury room. You may use your notes only to help you remember what happened during the trial. Your independent recollection of the evidence should govern your verdict. You should not allow yourself to be influenced by the notes of other jurors if those notes differ from what you remember. At the end of the trial, your notes will be collected and destroyed. You may request in writing that trial testimony be read to you. I will have the court reporter read the testimony to you. You may request that all or a part of a witness's testimony be read. Your request should be as specific as possible. It will be helpful if you can state the name of the witness, the subject of the testimony you would like to have read, and the name of the attorney or attorneys asking the questions when the testimony was given. The court reporter is not permitted to talk with you when she is reading the testimony you have requested. While the court reporter is reading the testimony, you may not deliberate or discuss the case. You may not ask the court reporter to read testimony that was not specifically mentioned in a written request. If your notes differ from the testimony, you must accept the court reporter's record as accurate. And one footnote there, just as it takes us some time to respond to your questions, it also takes us time to isolate the testimony that you're requesting, so please continue deliberating while you're waiting for a readback. I will give you a special verdict form with questions you must answer. I have already instructed you on the law that you are to use in answering these questions. You must follow my instructions and the form carefully. You must consider each question separately. Although you may discuss the evidence and the issues to be decided in any order, you must answer the questions on the verdict form in the order they appear. After you answer a question, the form tells you what to do next. At least 9 of you must agree on an answer before you can move on to the next question. However, the same 9 or more people do not have to agree on each answer. All 12 of you must must deliberate on and answer each question regardless of how you voted on any earlier question. Unless the verdict form tells all 12 jurors to stop and answer no further questions, each juror must deliberate and vote on all the remaining questions. When you have finished filling out the form, your presiding juror must write the date and sign it at the bottom of the last page, and then notify the bailiff that you are ready to present your verdict in the courtroom. To the alternate juror, the jury will begin deliberating after closing arguments, but you are still an alternate juror and are still bound by my earlier instructions about your conduct. Until the jury is discharged, do not talk about the case or about any of the people or any of the subject involved in it with anyone, and not even your family or friends, and not even with the other jurors. Do not have any contact with the deliberating jurors. Do not decide how you would vote if you were deliberating. Do not form or express an opinion about the issues in the case unless you are substituted for one of the deliberating jurors. In this case, I've exercised my right to comment on the evidence. However, you, the jury, are the exclusive judges of all questions of fact and the credibility of the witnesses. You are free to completely ignore my comments on the evidence and to reach whatever verdict you believe to be correct, even if it is contrary to any or all of those comments. After your verdict is read in open court, you may be asked individually to indicate whether the verdict expresses your personal vote. This is referred to as polling the jury and is done to ensure that at least 9 jurors have agreed to each decision. The verdict form that you will receive asks you to answer several questions. You must vote separately on each question. Although 9 or more jurors must agree on each answer, it does not have to be the same 9 for each answer. Therefore, it is important for each of you to remember how you have voted on each question, so that if the jury is polled, each of you will be able to answer accurately about how you have voted. And we're actually going to give you your own copy of the verdict form, so please keep track of your own votes on the verdict form. The final verdict form that the jury foreman will have will be the only one that's turned in, but please keep track of your votes on the verdict form that you're given for your own copy. If during the trial any of you had a question that you believe should be asked of a witness, you are instructed to write out the question and provide it to me through my courtroom staff. If a question was asked, or I decided whether the question could be asked. If a question was asked and answered, you are to consider the answer as you would any other evidence received in the trial. Do not give the answer any greater or lesser weight because it was initiated by a jury question. If a question was not asked, do not speculate as to what the answer might have been or why it was not asked. There are many legal reasons why a suggested question cannot be asked of a witness. Give the question no further consideration. During the trial, materials may have been shown to you to help explain testimony or other evidence in the case. Some of these materials may have been admitted into evidence, and you'll be able to review them during your deliberations. Other materials may have also been shown to you during the trial, but they have not been admitted into evidence. You will not be able to review them during your deliberations because they are not themselves evidence of any evidence or proof of any facts. You may, however, consider the testimony given in connection with those materials. All right, as I indicated, there's going to be some additional jury instructions that are going to be read on Tuesday. Why don't we plan on starting closing arguments at 9:45 on Tuesday? I need to meet with the attorneys at 9 o'clock, and while I think we'll be done by 9:30 to finalize everything, I don't want you to be waiting in the hallway. So let's plan on 9:45 on Tuesday. My expectation is we will be done with closing arguments before lunch, and that you will have the case to deliberate on after lunch on Tuesday. There are several causes of action, and so I do anticipate that it's going to take a bit of time to deliberate on each cause of action. And so I would have a pretty strong feeling that it is likely that you will also be here on Wednesday to finish deliberating. So at present, we're definitely going to be here Tuesday at 9:45. You can anticipate that you're not going to finish deliberating by the end of the day on Tuesday, and that you'll be here at least Wednesday morning to finish deliberations and to render your verdict. And then you guys will know how things are going as to how much longer into Wednesday or potentially Thursday things will take. Okay, any questions about that? please do your absolute very best to avoid any media. I know that there has been some coverage of it. If you happen to see something, just go ahead and turn it off, turn it away, whatever it may be. We don't want you to be influenced by any of the media coverage, okay? All right, we'll see you on Tuesday, 9:45.